If you're an American conservative, you know that the societal values we hold sacred are under attack. They are hanging in the balance. How can you protect those values? By staying informed. The Closing Argument will deliver news and supporting evidence you need to support and defend those values. Here's Paul Smith.
Good morning. This is Paul Smith, your host of The Closing Argument. In these podcasts, we discuss some of the important but controversial moral, political, and legal issues that affect us and our families today. Some of the things we discuss are not politically correct, but we must discuss them anyway, because this discussion is needed to preserve our liberties, to establish the truth, and to let the world know that there are many people who challenge some of the modern views that challenge traditional morals that really are destructive to America. Now, today we're going to talk about the state of the Supreme Court of the United States in 2022. This is appropriate now. We're recording this in early August 2022. We've had about a month to review the latest opinions of the U.S. Supreme Court that came out in late June. And we have a real good idea based on these several cases of where the Supreme Court is at. To give you an idea of where they're at, the liberals and Democrats are furious at the Supreme Court. They're very happy that people protest and go to their home and demonstrate in front of their homes. And the liberals in the Biden administration refuse to prosecute those who do that, even though it's in violation of federal law. They call for a packing of the court so that they can get more liberals on there to try to get their point of view passed in cases. So that gives you an idea of how the Supreme Court is doing. And the result is they're doing very well because people are upset. These people who are upset should not be. The Supreme Court now has a solid 6-justice majority of solid conservative justices. This is the best condition the Supreme Court has been in 60 years and maybe longer. I'm going to talk briefly about 6 cases. Now, in other podcasts, I have talked about 3 of these cases. I will mention those 3 again without going into a lot of depth about them. And then I'm going to talk about 3 other cases that I have not treated in other podcasts. So again, the cases that I'm going to discuss are Dobbs versus Women's Health, West Virginia versus EPA, New York State Rifle and Pistol Association. The 4th one is Carson versus Macon, Biden versus Texas, and the last one, Federal Election Commission versus Cruz. And again, these cases together stand for a healthy Supreme Court. Now, we've discussed the Dobbs case before, in fact, extensively in the previous broadcast. But the Dobbs case, of course, it deals with abortion and fetal rights, and I believe it came out the right way on that, putting the onus on the states and the state legislatures to resolve this. So the Dobbs case, what's so important about it is it supports federalism, and it makes it clear that the Supreme Court is not supposed to be a super dictatorial legislature that just feels that it has the authority and power to resolve issues about rights when those decision-making authorities should belong with the people and the states. And so this is good because the court in a number of cases in the last few years has just taken upon itself to just decide issues and to establish liberal viewpoints and to bypass legislative and democratic processes in order to advance the liberal agenda. And of course, the problem here is the Democrats want someone on the court to advance their agenda, whereas true conservatives recognize the role of the court is not to establish anyone's agenda. And so you may get more conservatives on the court, but that means that they're not necessarily going to advance conservative values if it runs afoul of the more important value of making sure the Supreme Court has self-restraint and does not interfere in states' issues. Second case we talked about in another broadcast is West Virginia versus the EPA. And this was very important because it appears to me that the Supreme Court clearly saw what was going on with the climate change hoax folks and checked them as they sought to interpret the Clean Air Act in a way that would allow the EPA to basically put out of business coal-fired power plants. And the Supreme Court in that case says, no, Congress didn't give such authority to the EPA. All it did was had authority to require coal-fired power plants to use the most technically advanced technology available to help reduce pollution, but did not give the EPA authority to shut down such power plants and prevent them from producing energy. A third case that we talked about in a prior podcast was the Federal Election Commission versus Cruz. And in that case, this dealt with the Bipartisan Campaign Finance Reform Act, which I have criticized many times. And in this case, it was the Supreme Court struck down another part of that law. And this one pertained to the law that a person in a campaign who lends money to his campaign could only repay himself from after election contributions to the extent of $250,000. I'm not sure if you could follow that. That was kind of a technical long sequence there. But Cruz had lent $260,000 to his campaign, and the law would only let him be repaid $250,000. He said that's a ridiculous and unconstitutional limitation, and the Supreme Court agreed. So on one hand, who cares? On the other hand, the problem with campaign finance reform is a lot of them are based on the feeling that if you can cut off money from campaigns, you somehow can make campaigns pure and so forth. But frankly, I am of the view money and speech are inseparably connected, and it's just very difficult to regulate speech through monetary limitations and to feel like you're really getting a better election system. So anyway, I was happy. That was fine. Now I want to talk about three other cases that you may not have heard so much about. The first one I want to mention is Carson versus Macon. All right, this is the case coming out of Maine. And here, this case upheld the state's right to take money for charter schools and so forth and give the state money to a religious-sponsored school. And the Supreme Court says, yeah, if the state is making money available to charter schools, you can't deny money going to one student because he's going to a religious school, as long as the school is otherwise qualified to teach. And the Democrats had a hissy fit about this. And now, when I first heard about this case, my thought was, well, this is a no-brainer. I mean, this issue's been dealt with by the Supreme Court numerous times. They have several times upheld the right of states to give money to religious schools. And so why the big deal? What's going on here? The problem in this case is the state of Maine did not want any benefits to go to a Christian school that had views about homosexuality and gender identity that were not in harmony with the radical and woke views of the day. And of course, that's one reason parents send their kids to private schools, because they want traditional values taught. They don't want the new woke views about multiple genders taught. And they don't want to encourage students to explore whether or not they might be gay. They want those things reserved to them as parents. And so that was why this case was such a big deal. But again, there is no wall of separation between church and state. It is a phrase that has been used for 200 years, and some of the liberals use it, along with the view that the government should be anti-religious, but that's not the case. The Supreme Court has consistently held that the government can recognize different religious beliefs as long as it does not establish one religion over the other. There is no freedom of or from religion in the Constitution. It is a situation of accommodating but not promoting any one particular religion. Another case that was interesting was the New York State Rifle and Pistol Association versus Bruen. This was a Second Amendment case, and basically, when I looked at this one, I said, why is this such a big deal? Didn't the court establish that there was an individual right to bear arms in the Heller case in 2008 and in the McDonald case in 2010? Well, it turns out the facts of both of those cases were such that in those cases, the person challenging it wanted to use a firearm in his or her own home. So now this new case from New York, someone asserted that he had the right to carry arms out in public outside of his home. And so, of course, the liberals, and there's a lot of them in New York, said, oh, wait a minute, you can't do that. And basically, this case ended up just rehashing what the Supreme Court went through in Heller and McDonald. Now, after the Heller and McDonald case, 43 of the states had established laws where someone could get a license to carry a gun just by basically asking for it, unless they were a felon or something. They are called shall-issue states. But there were, I think, 6 states, and I know there's a 7th, but there were 6 states and the District of Columbia who would only issue permits for someone to carry like a firearm if they could prove they had an immediate, urgent need for it. The Supreme Court basically said that this approach violates the Constitution. A person does not need to show any imminent danger or emergency need for a gun in order to have the right to carry, because the right to bear arms is fundamental in the Constitution. And the Supreme Court said, that's what we said in Heller and McDonald's, and you should have, it was right there, and you're asking us to second guess it, but you were wrong. So this was an encouraging case. It shows the left's unrelenting opposition to those cases and their continuing desire to destroy the Second Amendment. So it didn't work this time. And finally, the last case I want to talk about is Biden versus Texas. Now, this is one, when I heard about it, I thought, well, why is this case a big deal? Again, President Trump had issued an executive order that was in place preventing some immigrants from coming to America. And then Biden, after his election, he passed an executive order rescinding it. So my thought was, well, why can't the president rescind it? Now, I wish he wouldn't. In terms of substance, I thought Trump's executive order was helping the U.S., and Biden's attempt to rescind it was a stupid and harmful act. But it seemed to me, if it's an executive order, why can't he reject it, rescind it? Well, it turns out there was another issue here that caused it to get all the way to the Supreme Court, and that was some people, including the Fifth Circuit Court of Appeals, felt that the statute, this immigration statute that was involved, had language that was mandatory shall language that the court, that the judge needed, that the